I was in court one day waiting for our case to be called, and now I'm sitting next to my opponent. My opponent turns to me and says, "Listen, what do you need to settle this case?" Now we were close to trial, and now we were going before the judge. We were waiting to see the judge for a pretrial settlement conference. I turned to my opponent and I said, "I need $1 million. My opponent turns back to me and said, "Listen, if we gave you $950,000, would it settle the case?" Would you like to know what I said? Come join me for a walk through the neighborhood as I share with you exactly what I said. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. All right, so this is a medical malpractice case. This case had been going on for more than 2 years, and we were close to trial. During the course of the litigation, the defense attorney, the same one that I was now sitting next to, had approached me and said, "Listen, we'd like to try and resolve this case without the need of going to trial. Can you give me a demand?" And I said, "Sure, I'm happy to give you a demand. I'll get back to you shortly." So during the course of the litigation, I made a demand of $3 million. And the defense attorney told me that there's no way they're going to voluntarily go ahead and pay $3 million. He said, if you need that kind of money, you're going to have to get it from a jury. And then you're going to have to go ahead and get it from an appellate court who confirms and upholds that particular verdict. I said, "That's fine." Now, I said, "Look, if you want to really negotiate, you have to come up with a good faith settlement offer to tell me that you're really interested. Just saying no to my demand doesn't mean much." He said, "Fine, I'll go back and I'll call you back shortly." About 2 weeks later, he calls me back and he says, "Listen, we have $250,000 to offer." And what did I say? I said, "Absolutely not." I say, "I appreciate your good faith settlement offer. However, that is nowhere near where I need to be." He said, "Understood, there's more money available, but it was our initial offer." I said, "Okay." Now, he expected me to come down off my demand, which I did. I came down off my demand to $2,500,000. Now, why did I do that? Because I knew that my client's injuries were not worth $3 million. I knew that on appeal, that my client's injuries were not worth $2.5 million either. The defense attorney knew that well. And what's remarkable is that the defense attorney knew the full value of my client's injuries. But this is all a negotiation tactic. It's a negotiation strategy. I know what the true value of my client's injuries are. The defense knows what the true value of my client's injuries are for settlement purposes. Neither one of us want to get there first. Why? Because we want to save money. He wants to save money. I want to get as much as possible for my client. And that's the competing interest here. My goal is that I try and get as much money as possible to compensate my client for all the harms and losses and damages that my client suffered. His goal is to try and save his client as much money as possible without having to give away the store. And those are the competing interests that occur anytime we have a negotiation for this type of case. So now fast forward to we're sitting in court waiting for the case to be called for a pretrial conference. And now the defense turns to me and says, "Listen, will you take $950,000? And I said, "No, I won't." I said, "I told you that $1 million would settle this case." So now let me step back for a second. How did I go from $2.5 million down to $1 million? Because we continued having settlement discussions throughout the course of this litigation. And I knew that the true value of my client's injuries for settlement purposes was $1 million. The defense also knew and pretty much acknowledged that my client's injuries were at the right valuation of about $1 million. However, his client did not want to pay the full $1 million in order to settle the case. So instead they came back with what I felt was a cheap offer of $950,000. Now, how could that be a cheap offer if I've already told you that their initial settlement offer, their good faith offer of $250,000 was a substantial settlement offer? I'll tell you why. It's because I had spoken to my opponent, my adversary, and we were very pleasant to each other. We had a very good professional working relationship. And I told him outright, I said, "Listen, I need $1 million and not a dime less. If you come back to me with less than that, I can't accept this offer. We'll go ahead and try this case." He said to me, "You're not going to try this case over $25,000 or over $10,000 or over $75,000. I said, "Yes, I will." And that's because my client feels, and I believe, that this case has a value of $1 million. And if you don't agree, fine, let's have a jury decide whether or not we're right. Now, we're sitting waiting in court. He now tells me, listen, he doesn't tell me he has the $950,000. He asks me, he said, look, if I got you $950,000, would it settle your case? The answer that I said to him was, no, it wouldn't. And he was somewhat shocked. He said, you're going to try this case over $50,000? I said, yes, I will. Because I told you during the course of our discussions that I need $1 million to settle this case. I don't need $950. If I needed $950 to settle this case, I would have told you I need $950. Now, I don't come right out initially and say, look, I need $950,000 to settle, because I know he would never reach that point. Instead, he would always give me something that was lower than that. I had started at $3 million, then I went down to $2,500,000, then I went down to $2 million, and I kept going down in increments as he kept coming up, ultimately with the goal to try and get to $1 million. And if I did not have as good a relationship as I did, I never would have told him that I need $1 million to settle the case after negotiating, because that's not what we would do, because then I know I would never get to that point. But he knew exactly what I needed, and instead of coming back, he's still trying to save a few dollars to look good to his insurance company. Why? Because then he looks like a hero. Then it looks like he beat me up and now came out on top during this negotiation. And that's not a great strategy to use. So, what happened? We now go in front of the judge. The judge says, okay, he turns to the defense attorney and says, okay, do you have any money? He says, Judge, my client is willing to offer Mr. Oginski $950,000, but Mr. Oginski is not willing to accept it, and his client is not willing to accept it. He needs $1 million. And the judge turns to me and says, is that true? I said, yes, Judge, that is exactly true, and I told him that this case could be settled for $1 million and not a dime less. And now he turns to the defense and says, go make a call, meaning he wants him to go get the additional $50,000 because he knows that he does not want us trying this case over $50,000. And reluctantly, my opponent actually went ahead and made a call to his principals, and a short while later came back, and now he had to report back to the judge. And the judge said, okay, so what's your answer? He says, okay, case settled, $1 million. So why do I share this with you? I share this with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.